defamation and slander remain most commonly prosecuted offenses against journalists. Article 173 criminalizes accusing someone of dishonorable conduct or making statements that damage reputation, while Article 174 covers knowingly false allegations. The key limitation: even truthful reporting loses protection when it concerns private or family life without clear public interest. Courts interpret this Canada Action plus 2 SWI swissinfo.ch SWI swissinfo.ch plus 4B plus 5 Carderock Wikipedia any RSL Carderock Fee Media Teichmann Law plus 2 broadly, leaving journalists vulnerable when reporting on public figures' conduct that intersects with personal matters. Article 293 prohibition on publishing secret official proceedings creates particular challenges for political and investigative reporters. The provision covers not just classified documents, but any information from proceedings authorities deem confidential. Unlike some countries providing whistleblower or public interest exceptions, Swiss law offers no escape clause. Publication itself constitutes the crime regardless of content, significance, or public benefit. Article 320 on official secrecy extends criminal liability indefinitely. Former government employees cannot disclose information learned through official positions without written superior authorization, even decades after leaving service. This provision effectively blocks insider sources from revealing government wrongdoing to journalists, who face prosecution as accomplices for receiving such information. The law's breadth covers not just state secrets, but any information authorities consider confidential. Article 47 of the Banking Act represents the most extreme restriction. The 2015 amendment explicitly extended criminal liability to third parties, including journalists, closing previous ambiguities. The law criminalizes revealing even the existence of a Swiss bank account, let alone transaction details or evidence of criminal activity, with penalties up to 5 years imprisonment and CHF 250,000 fines. This provision imposes the harshest punishment for financial journalism found in any democracy. The interaction between these provisions creates compounding risks. A single investigation might trigger liability under banking secrecy, official secrecy, and defamation laws simultaneously. The absence of public interest defenses across these statutes means journalists cannot justify publication based on exposing corruption, protecting public safety, or serving democratic accountability. Press freedom organizations condemn Swiss restrictions. International press freedom organizations have issued increasingly sharp criticism of Switzerland's legal framework, particularly following the 2024 criminal prosecution of journalist Lucas Hessig. Their assessments reveal how Switzerland's approach violates international standards and democratic norms. Reporters Without Borders currently ranks Switzerland 9th globally, but notes significant legal framework weaknesses. The organization specifically criticized the 2022 tightening of provisional measures allowing easier pre-publication injunctions. This section Representative Denis Mazmedjan called applying banking secrecy to media absurd and incompatible with the freedom of the press. The organization views Switzerland's code filing Epfel Swiss rights Epfel EBI plus 2 Acapipia BGLIOS plus 7 RSF SWI Swissinfo.ch AGA trajectory is concerning, while maintaining high security scores for journalist safety. Legal restrictions create a less favorable political climate than in the past. The UN Special Rapporteur on Freedom of Expression, Irene Khan, delivered the harshest criticism, calling Article 47 an example of the criminalization of journalism that paralyzes freedom of expression and media freedom. In formal communications to the Swiss government, she emphasized that the banking law violates human rights by lacking explicit exemptions for journalists and whistleblowers. Her assessment that such restrictions belong in authoritarian states rather than democracies represents unprecedented UN criticism of Swiss press laws. The International Press Institute labeled Switzerland's banking secrecy laws draconian and called for urgent reform. IPI emphasized how the lack of public interest provisions allows the Swiss Banking Act to be misused to criminalize legitimate, public interest journalism. The organization particularly noted the global implications. Swiss laws don't just affect domestic journalists, but create risks for international reporters investigating Swiss banks' role in global corruption. OZ representative on freedom of the media, Teresa Ribeiro, characterized the banking law's effect as creating prior censorship through self-censorship, stating this is normally a problem in authoritarian states. She stressed that under international law, journalists have a right to write about matters of public interest, and that media must fulfill their fundamental role to act as society's watchdog. Swiss press organizations echo international concerns. In Pressum, the Swiss Journalists Association declared that one of democracy's fundamental pillars is under attack and requested government action to reverse these trends by reinforcing press press freedom. The organization particularly highlighted how legal threats create an atmosphere encouraging self-censorship beyond formal prosecutions. Balancing press freedom with privacy and state interests, Swiss law ostensibly balances press freedom against competing interests like privacy, reputation, and state security, but critics argue the scales tip heavily against journalism. The constitutional framework appears robust. Article 17 explicitly guarantees press freedom and source protection, yet implementation through criminal law undermines these protections. The privacy versus public interest calculation particularly disadvantages journalists. While many democracies recognize that public figures accept reduced privacy expectations, Swiss courts maintain strict protection even for prominent individuals' private matters. The absence of a clear RSF IBI plus 9 OCUP IBI plus 3 IBIOS SWI Swissinfo.ch constitutor protect plus 2 SWI Swissinfo.ch plus 3 public figure doctrine means journalists risk prosecution for reporting on powerful individuals' conduct even when it affects their public roles or involves abuse of position. State security justifications for restricting press freedom prove especially problematic given Switzerland's broad interpretation. Article 293 prohibition on publishing secret proceedings applies not just to genuine security matters.